To avoid further disruption and allow for filing incorrect districts, this court needs to stay this by December 1st and enter a stay while it considers this application. If his testimony does not conclusively demonstrate a non-racial, partisan explanation for this redistricting, it's difficult to imagine what possibly could. What else do you need to see? It's like, okay, you think it's so racist, you try drawing a map that isn't racist, and let's see what you come up with. And then they're like, well, we can't do it either. Like, exactly, okay, it's not racist, it's just partisan. Supreme Court steps in and saves the Texas maps. We saw this battle brewing over there between Greg Abbott, the League of United Latin American Citizens, and an order came down from the lower level district judge that said that Texas was a little bit too racist, and there were certain demographics that are being picked on with these new maps that were duly passed into law by the Texas legislature and signed into law by Governor Greg Abbott. Then we had these judges come down and very quickly, urgently pass an opinion because they said the elections are coming up very soon. So they reverted the new maps that added presumably red seats to the equation, reverted it back to the 2021 maps, and deletes those Republican gains. Now, this is all simultaneous with California adding in additional seats. So they got more points on the board. Republicans had their points on the board until this lower level judge reversed it. Then Judge Alito, he came in and he said, you know, we've considered the application of Ken Paxton, and Ken Paxton wins for now. Says here, it is ordered that the November 18th order of the Western District of Texas from Judge Brown, a Trump appointee, is now stayed pending further order of the undersigned or of this court. So the Supreme Court stepping in, and this was the status quo. The judge in the lower level court, Western District of Texas, was trying to reverse the status quo. The current law was new districts created based on the new map. He reversed it because he didn't like the outcome. It was going to give the Republicans more seats, and they want the Democrats to take over the House after the next election. So he says, it's further ordered. We want a response before Monday, November 24th. So coming up quick. We're going to rule on this stuff quickly. Signed by Judge Alito. Thank you, Judge Alito, for bringing back a semblance of sanity. And we read through some of the dissent from the lower level decision, and that judge was fuming mad. Didn't even get apprised of the decision before they published it. They said, sorry, we're not going to allow you to have your dissent in here because we have to get this decision done before these deadlines occur so that we can make sure that new candidates filing to run in these seats use the old map, not the new one. Then once that process is underway, then you can't go back to the new map because you're already using technically the old map, right? So they were trying to get that all done and anchored in, but now they have been stayed. Ken Paxton, celebrating, says, breaking, in response to our filing, the Supreme Court just granted an administrative stay, temporarily stopping the district court's injunction against Texas's map. We look forward to continuing to press forward in our case on the merits. And the actual application came in, and here is what it looked like over from the Attorney General of Texas. An emergency application to the Supreme Court of these United States. They say, all right, you know all these people. We've got the state of Texas, Greg Abbott, and then we have a bunch of people. All of these people, look at them all suing. Texas Hispanics, Workers Defense, tons of names, NAACP, and all the people who were screaming that everything is racist, including Jasmine Crockett. Oh, isn't that nice? Now, there was a 3-judge panel that was ruling on this election stuff, and we saw how they came down, and now we're at the Supreme Court. Here's what convinced Alito to give us our map back. They said this summer, the Texas legislature, Supreme Court, they did what legislatures do. It's called politics. It redistricted the state's 38 districts mid-decade to secure 5 Republican seats for the House. Other states did the same. California is adding more Democrat seats right now. Democrats already in California, they already control 43 out of 52 of their total seats. Virginia Democrats are doing the same thing. They're actually adding a constitutional amendment right now. So they answered with litigation. They sued us. They asked the 3-judge panel to stop our new maps from going into play. Now, over a dissent, the panel majority did exactly that. They recast the partisan gerrymander as a racial one. They said, of course, redistrict based on you win, redistrict for partisan purposes, but you can't do it for racist purposes. So they just said, well, this looks racist. And they allowed them to use this as a weapon of political warfare. Now, the majority failed to hold these people suing, saying everything's racist, to their demanding burden. Okay, they have to disentangle race and politics. It disregarded the fact that when partisanship and race correlate, it naturally follows that a map has been gerrymandered to achieve a partisan end. It can look very similar to race, but it doesn't automatically mean it's racist. it failed to follow the strong presumption that the legislature was acting in good faith. It directs the courts to draw the inference that cuts in our favor. The legislature gets a presumption that they're not racist. It rejected the state's defendants, Texas, their powerful evidence of good faith. In fact, we had unrebutted testimony of the map drawer. He went district by district, sometimes line by line. He gave a political or practical reason for the decision of every line on the map. Everyone. And they were practical or political. They were not racial. And the majority excused their failure to provide an alternative map. The court said, well, this could be clear error or would be clear error. And so you have to stop this. This is something that you are going to reverse anyways, and we have an upcoming deadline imminently. Compounding the harm, the lower level court entered this injunction far too late in the day, 10 days after the candidate filing period had already opened. Okay, so people are already in Texas registering according to the new map. The judge comes in, says, nope. The injunction changes the boundaries of all but one of the 38 districts, stopping Texas from using the new map, making us go back to the old one. The chaos caused by this injunction is obvious, okay? Campaigning had already begun. Candidates already gathered signatures and filed applications to appear on the ballot under the new map. Early voting for the March primary was only 91 days away. The lateness of this injunction, 38 days after the hearing alone, warrants a stay. Purcell, don't interfere and make changes right before elections. With the headline and the deadline for the candidate filing rapidly approaching on December 8th, to avoid further disruption and allow for filing incorrect districts, this court needs to stay this by December 1st and enter a stay while it considers this application. Whew. And Judge Alito did that. Thank you, the Honorable Samuel. In June 2025, in an effort to preserve the Republican majority in the House, Trump began urging people, redistrict. They're doing it to us all over the place. The Department of Justice sent a letter to Texas. Then Abbott said, yeah, actually, let's put this on the special agenda. Then to achieve its partisan goals, the Republicans did that. In fact, this person came in, he was hired by the RNC. They started looking at the map. Two primary goals of the new map. Well, one is to protect incumbents. The other is to create new Republican strongholds. They did that. They did it. They achieved those aggressive partisan goals. They used proprietary data, and we explained exactly how he'd do it. He never even considered racial data. He did not even have racial data visible on the computer. At the hearing, testifying for 2 days without notes, he went district by district, sometimes line by line, explained the logic behind all of this. All of it was using partisan, race-neutral criteria. Even the majority said that this is what he did. There was not even a racial connotation at all. The dissent from the lower level court details district by district exactly how this worked, and they found that there was no racism. However, the lower level court said it was racist, and the Democrats controlled some seats in the old map, then they didn't, and they're explaining, who was an incumbent, who's going to keep the maps, explain exactly how he drew it. As even the majority found, the defendants, Texas, they presented a specific, detailed, non-racial, unrebutted explanation for every single decision that was made. Not racist at all, no. Kincaid's testimony was internally consistent. Not a single explanation was undermined or falsified. No expert ever produced an alternative map that duplicates those goals. If his testimony does not conclusively demonstrate a non-racial, partisan explanation for this redistricting, it's difficult to imagine what possibly could. What else do you need to see? Now, from the very beginning, we knew that the effort was to create a Republican political advantage. You're allowed to do that. It's political. It's called politics. U.S. House Minority Leader Hakeem Jeffries said there's an arms race that's happening, and many of their states have already been redistricted to the tilt. As the map moved through the steps, many people reviewed the data. Every vote followed partisan, not racial lines. Then Abbott signed it into law. But even before the map was signed into law, a bunch of Democrats came screeching in here. Hey, this is racist. Nearly 40 days later, then the lower court stopped us. They said, no 2025 map. This is white people exercising their bigotry. Now, the conclusion, they said, of the lower level court is, to put it mildly, implausible, all right? They would be right only if there was some racism and connotation to it, but there wasn't. And election deadlines began before the court enjoined the 2025 map, all right? So the new map was already underway. Well before the injunction, candidates had already started campaigning based on the new map. The filing period began November 8th, and they came down and tried to reverse it. Changing the primary date could be catastrophically bad, okay? Everybody has to reverse all the things they're already doing, and that's why we need to stay. Under Purcell, you can't come in and meddle with this stuff. This court has repeatedly said says lower federal courts should ordinarily not alter election rules on the eve of an election. Okay, stop manipulating everything so you can win. And Purcell and others, this flouts Purcell. Even before this hearing, candidates had already selected the districts in which they were going to run. The filing period opened 13 days ago, which is why they had to race this through and to try to change it. No evidence at the hearing justified the district court's failure to follow Purcell. There was no urgency that required reversing the status quo, so they made tremendous mistakes. Nor was there any correctness not to apply Purcell, saying we are far enough out. The legislature, the governor signed it into law, then the judge just came in and suddenly reversed it. And we're going to win. This is a bad injunction. The judge didn't properly apply all the factors of an injunction. They didn't even produce an alternative map. This is a straightforward error, is that they have to do this, okay? The other case law called Alexander, it says that a plaintiff's failure to submit an alternative map, precisely because it can be designed with ease, should be interpreted as an implicit concession that the plaintiff cannot draw a map that undermines the legislature's defense that the districting lines were based on permissible rather than a prohibited ground, right? If this map is racist, show us one that is not and explain why. But this judge, he couldn't do that because there wasn't enough time to go create a new map, right? He couldn't order the legislature to go redo this whole thing. That's why he reverted back to 2021. He said, well, you already did that map. That map was good. So you don't have to go create a new map. You don't have to create an alternative map. Just go use the old one, which gives the Democrats their seats back. And that's his little scam. But they say, Alexander says you need an alternative map. It's undisputed that they failed to submit an alternative map. Alexander, the case law, requires a fact finder treat this failure as a concession, that they can't draw one that would beat our map. It's like, okay, you think it's so racist? You try drawing a map that isn't racist and let's see what you come up with. And then they're like, well, we can't do it either. Like, exactly. Okay, it's not racist. It's just partisan. This reasoning is backwards. Plaintiffs who seek the extraordinary remedy of an injunction have to come in here, particularly one disrupting our electoral process at the 11th hour. We're already in the election process. They have to provide some actual evidence. If no map was offered here, it would be malpractice to redistrict this without a map. And the law says there is an inference in our favor. This is a clear error. Not only does the district court disregard the fact that these maps can be designed with ease, but plaintiffs' expert purportedly generated tens of thousands of pro-Republican maps that obey traditional redistricting principles without being racist. Now, if this were true, they could have submitted an Alexander map, but they didn't even ask the question. Why did they not introduce a single map? How come? At minimum, it requires an adverse inference saying that they can't create a better map. If plaintiffs and their expert, the people suing, had time to generate tens of thousands of other maps, there was more than ample time to follow the case law that says you have to propose a map. Said it would be clear error for the judge to overlook the shortcoming of producing an alternative map. That's the case law. This judge didn't follow it, and there was no racial intent. They say also the lower court failed to find that there was any direct evidence of racial intent. There was no evidence proffered at all. There is no statement from any relevant state actor acknowledging the role of race. In fact, it's the opposite. So they erroneously characterized three pieces of evidence as direct evidence. One, Harmeet Dillon, statements in a letter from her saying you have to redistrict. They said there were statements in that. Harmeet, as you know, she's a white male who's racist, fighting for Nazis and white pride. Okay, it's a joke. She's not that. Says here, statements by Governor Abbott in his proclamation and others. But all these statements are not even applicable. First of all, Harmeet is not a state actor. That's that one. And Governor Abbott's statements about increasing the number of majority Hispanic districts reflected the correct observation that minority voters in Texas are in fact moving towards the Republican Party. In any event, the motivations of the DOJ and the governor are only relevant to the extent that other evidence connects them to the legislature as a whole, and the legislature drew the map. There is no evidence of any racial intent in the legislature. They walk us through more on that. Now, they found that there were a statement of handful of legislators who may have made statements that were close to that, but the dissenting judge is saying these are floor statements and these are awareness. These are mere awareness of racial compositions. It's not showing any intent to draw racially gerrymandered districts. But the district court speculated that, well, maybe there was some racism in the partisan targets, and so just kind of shoehorned that in there. They relied on other evidence that just doesn't meet muster here and credited one of 6 experts with a lot of their conclusions, saying that it was racist at the lower level, but they erred by not ruling out the possibility that these aspects of the map were a side effect of the partisan goals. Like there might be, some racial effects. Anytime you make a change to anything, you can make an argument. Well, that's going to impact one group more than another group because we're changing something. But it's not the target of the action, and there's no evidence to show that. All of the other stuff is just tangential and not significant enough to reverse the status quo. You can see in conclusion, they say we need a stay, Judge Alito. If Purcell and changing the election rules in the middle of the election doesn't independently compel a stay, it demonstrates that we're going to have serious harm with this 11th hour injunction. There's a real risk of preventing candidates from even making their way on the ballots according to the new maps. And so we want you to stop this. The state's election is already in progress. They enjoin the new map outside of the law. And so for these reasons, we ask you to enter a stay, and we respectfully request a ruling by December 1. You got it already. You got it in like 12 hours. This court should also construe this as a jurisdictional statement to expedite the appeal, signed courtesy of Ken Paxton, and Alito came down and said, granted. Administratively stayed by Samuel Alito, so those old maps revert back. And that's a big win. So by Monday, they want another decision, and we'll see how quickly the Supreme Court acts on this. But as it stands, the lower level judge who tried to cram this through, tried to violate the will of the Texan people who all voted for their legislators to go into the legislature and to pass legislation that reflects their will. They did exactly that. Abbott signed it into law. Hack judge reversed it. Now that judge is stayed. Original maps are back, baby, and that's great news.